Welcome to the Law of Self-Defense Show. I am, of course, Attorney Andrew Branca for Law of Self-Defense. Thank you oh so much, as always. Well, we're continuing with our reading of seminal U.S. Supreme Court decisions on the Second Amendment, now moving on from Heller and McDonald, which we previously shared with you, to the 2022 decision of Bruen, which found that the Second Amendment right to keep and bear arms is an individual right, which was found in Heller, as applied to the states, as found in McDonald, also applies to keeping and bearing arms in public, as found in Bruen. Now, in Heller and McDonald, we only read the majority decisions. Those are from 2008, 2010. But because Bruen is so new, we read the entirety of the Bruen decision. It's over 3 hours of content. So we've chopped it up into more digestible parts. In total, 7 parts, roughly 30 minutes each. So we're going to begin today with the starting reading, an overview, a syllabus of the case, and the first part of the majority decision, which was written by Clarence Thomas. So the majority here were Clarence Thomas, Chief Justice John Roberts, also Justice Alito, Justice Kavanaugh, and Justice Barrett. Now, Alito, Kavanaugh, and Barrett each wrote concurring opinions. Each of those are short, so I combined all the concurring opinions into the 5th episode of the 7-part series. The first 4 parts of this series are the first 4 quarters of Justice Thomas Clarence's majority decision. Then we have Section 5, which is the 3 concurrences, again by Alito, Kavanaugh, and Barrett. Section 6 is the first half of the dissent by Justice Breyer, and the last Section 7 is the second half of the dissent by Justice Breyer. Yes, it's a lot of content. So let's go right ahead, jump into the kind of overview syllabus and the first quarter of Justice Thomas's majority opinion in New York State Rifle and Pistol Association v. Bruen right now. Hey folks, if you like this Law of Self-Defense content, and I know you do, that's why you're here, you may as well consider picking up a free copy of our best-selling book, The Law of Self-Defense Principles. It's a real physical book. It's not just a PDF download. You can check it out on Amazon, where it's 5-star rated, over 1,400 reviews, but don't buy it on Amazon. They'll charge you for the book and the shipping and handling. We only ask that you cover the cost of shipping the book to you. The book itself is free. You can get this book, learn more about it at lawofselfdefense.com/free book. Hey folks, Attorney Andrew Branca here from Law of Self-Defense, and welcome to one of our continuing series of readings of U.S. Supreme Court decisions on the Second Amendment. Now, of course, we do self-defense law here at Law of Self-Defense. We don't do gun law per se, but naturally, guns are among the most common implements used by law-abiding citizens to defend themselves, their families, their property from criminal predation. They're involved in most claims of self-defense. And as you may know, I personally consider myself a Second Amendment absolutist, by which I mean that as far as I'm concerned, personally and professionally, every gun control law preemptively applied to mentally sound, law-abiding American citizens is facially unconstitutional. Despite my feelings on the matter, make no mistake, they will put you in prison for gun crimes. That's the world in which we live. We've been blessed, however, to have a number of recent U.S. Supreme Court decisions that have greatly strengthened the individual right to keep and bear arms under the U.S. Constitution. And so I've decided to record readings of these most important decisions, particularly Heller, McDonald, and Bruen. This reading is of Bruen. I will link to the text version of Bruen in the description to today's show. I'll also link, when I've done them, to the readings of Heller and McDonald. I haven't done those yet as of the date of this recording, but I'll get to those eventually too. And I'm doing this largely as a service to the community. So those of you who are interested, who don't want to read a dozens of pages long U.S. Supreme Court decision, you might prefer to listen to it as a podcast or watch it played in the background as a video. You can now do that with this reading of New York State Rifle and Pistol Association v. Bruen. Now, that said, I'll start with the syllabus of the decision, which is kind of an executive summary of the much lengthier decision, even though the syllabus itself is not short. So starting here with the syllabus to Bruen. The state of New York makes it a crime to possess a firearm without a license, whether inside or outside the home. An individual who wants to carry a firearm outside his home may obtain an unrestricted license to have and carry a concealed pistol or revolver if he can prove that proper cause exists for doing so. An applicant satisfies the proper cause requirement only if he can demonstrate a special need for self-protection distinguishable from that of the general community. Petitioners Brandon Koch and Robert Nash are adult, law-abiding New York residents who both applied for unrestricted licenses to carry a handgun in public based on their generalized interest in self-defense. The state denied both of their applications for unrestricted licenses, allegedly because Koch and Nash failed to satisfy the proper cause requirement. Petitioners then sued respondents, state officials who oversee the processing of licensing applications, for declaratory and injunctive relief, alleging that respondents violated their Second and 14th Amendment rights by denying their unrestricted license applications for failure to demonstrate a unique need for self-defense. The district court, that's the trial court, dismissed petitioners' complaint, and the Court of Appeals affirmed. Both courts relied on the Second Circuit's prior decision in Kachalski v. County of Westchester, which had sustained New York's proper cause standard, holding that the requirement was substantially related to the achievement of an important government interest. Held. New York's proper cause requirement violates the 14th Amendment by preventing law-abiding citizens with ordinary self-defense needs from exercising their Second Amendment right to keep and bear arms in public for self-defense. In District of Columbia v. Heller and McDonald v. Chicago, the court held that the Second and 14th Amendments protect an individual right to keep and bear arms for self-defense. Under Heller, when the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct, and to justify a firearm regulation, the government must demonstrate that the regulation is consistent with the nation's historical tradition of firearm regulation. Since Heller and McDonald, the Court of Appeals have developed a two-step framework for analyzing Second Amendment challenges that combines history with means and scrutiny. The court rejects that two-part approach as having one step too many. Step one is broadly consistent with Heller, which demands a test rooted in the Second Amendment's text as informed by history. But Heller and McDonald do not support a second step that applies means and scrutiny in the Second Amendment context. Heller's methodology centered on constitutional text and history. It did not invoke any means and test, such as strict or intermediate scrutiny, and it expressly rejected any interest-balancing inquiry akin to intermediate scrutiny. Historical analysis can sometimes be difficult and nuanced, but reliance on history to inform the meaning of constitutional text is more legitimate and more administrable than asking judges to make difficult empirical judgments about the costs and benefits of firearms restrictions, especially given their lack of expertise in the field. Federal courts tasked with making difficult empirical judgments regarding firearm regulations under the banner of intermediate scrutiny often defer to the determinations of legislatures. While judicial deference to legislative interest balancing is understandable, and elsewhere appropriate, it is not deference that the Constitution demands here. The Second Amendment is the very product of an interest balancing by the people, and it surely elevates above all other interests the right of law-abiding, responsible citizens to use arms for self-defense. The test that the court set forth in Heller and applies today requires courts to assess whether modern firearms regulations are consistent with the Second Amendment's text and historical understanding. Of course, the regulatory challenges posed by firearms today are not always the same as those that preoccupied the founders in 1791 or the Reconstruction generation in 1868. But the Constitution can and must apply to circumstances beyond those the founders specifically anticipated, even though its meaning is fixed according to the understanding of those who ratified it. Indeed, the court recognized in Heller at least one way in which the Second Amendment's historically fixed meaning applies to new circumstances. Its reference to arms does not apply only to those arms in existence in the 18th century. To determine whether a firearm regulation is consistent with the Second Amendment, Heller and McDonald point towards at least two relevant metrics. First, whether modern and historical regulations impose a comparable burden on the right of armed self-defense, and second, whether that regulatory burden is comparably justified. Because individual self-defense is the central component of the Second Amendment right, these two metrics are central considerations when engaging in an analogical inquiry. To be clear, even if a modern-day regulation is not a dead ringer for historical precursors, it still may be analogous enough to pass constitutional muster. For example, courts can use analogies to long-standing laws forbidding the carrying of firearms in sensitive places, such as schools and government buildings, to determine whether modern regulations are constitutionally permissible. That said, respondents attempt to characterize New York's proper cause requirement as a sensitive place law lacks merit because there is no historical basis for New York to effectively declare the island of Manhattan a sensitive place simply because it is crowded and protected generally by the New York City Police Department. Having made the constitutional standard endorsed in Heller more explicit, the court applies that standard to New York's proper cause requirement. It is undisputed that petitioners Koch and Nash, two ordinary, law-abiding adult citizens, are part of the people whom the Second Amendment protects. And no party disputes that handguns are weapons in common use today for self-defense. The court has little difficulty concluding also that the plain text of the Second Amendment protects Koch's and Nash's proposed course of conduct, carrying handguns publicly for self-defense. Nothing in the Second Amendment's text draws a home/public distinction with respect to the right and keep and bear arms, and the definition of bear naturally encompasses public carry. Moreover, the Second Amendment guarantees an individual right to possess and carry weapons in case of confrontation, and confrontation can surely take place outside the home. The burden then falls on respondents to show that New York's proper cause requirement is consistent with this nation's historical tradition of firearm regulation. To do so, respondents appeal to a variety of historical sources from the late 1200s to the early 1900s. But when it comes to interpreting the Constitution, not all history is created equal. Constitutional rights are enshrined with the scope they were understood to have when the people adopted them. The Second Amendment was adopted in 1791, the 14th in 1868. Historical evidence that long predates or postdates either time may not illuminate the scope of the right. With these principles in mind, the court concludes that respondents have failed to meet their burden to identify an American tradition justifying New York's proper cause requirement. Respondents' substantial reliance on English history and custom before the founding makes some sense, given Heller's statement that the Second Amendment codified a right inherited from our English ancestors. But the court finds that history ambiguous at best and sees little reason to think that the framers would have thought it applicable in the New World. The court cannot conclude from this historical record that, by the time of the founding, English law would have justified restricting the right to publicly bear arms suited for self-defense only to those who demonstrated some special need for self-protection. Respondents next direct the court to the history of the colonies and early republic, but they identify only 3 restrictions on public carry from that time. While the court doubts that just 3 colonial regulations could suffice to show a tradition of public carry regulation, even looking at these laws on their own terms, the court is not convinced that they regulated public carry akin to the New York law at issue. The statutes essentially prohibited arms in a way that spread fear or terror among the people, including by carrying of dangerous and unusual weapons. Whatever the likelihood that handguns were considered dangerous and unusual during the colonial period, they are today the quintessential self-defense weapon. Thus, these colonial laws provide no justification for laws restricting the public carry of weapons that are unquestionably in common use today. Only after the ratification of the Second Amendment in 1791 did public carry restrictions proliferate. Respondents rely heavily on these restrictions, which generally fell into 3 categories: common law offenses, statutory prohibitions, and surety statutes. None of these restrictions imposed a substantial burden on public carry, analogous to that imposed by New York's restrictive licensing regime. Common law offenses. As during the colonial and founding periods, the common law offenses of affray, or going armed to the terror of the people, continued to impose some limits on firearm carry in the antebellum period. But there is no evidence indicating that these common law limitations impaired the right of the general population to peaceably public carry. Statutory prohibitions. In the early to mid-19th century, some states began enacting laws that proscribed the concealed carry of pistols and other small weapons. But the antebellum state court decisions upholding them evince a consensus view that states could not altogether prohibit the public carry of arms protected by the Second Amendment or state analogs. Surety statutes. In the mid-19th century, many jurisdictions began adopting laws that required certain individuals to post a bond before carrying weapons in public. Contrary to the respondent's position, these surety statutes in no way represented direct precursors to New York's proper cause requirement. While New York presumes that individuals have no public carry right without a showing of heightened need, the surety statutes presume that individuals had a right to public carry that could be burdened only if another could make out a specific showing of reasonable cause to fear an injury or breach of the peace. Thus, unlike New York's regime, a showing of special need was required only after an individual was reasonably accused of intending to injure another or breach the peace, and even then, proving special need simply avoided a fee. In sum, the historical evidence from antebellum America does demonstrate that the manner of public carry was subject to reasonable regulation, but none of these limitations on the right to bear arms operated to prevent law-abiding citizens with ordinary self-defense needs from carrying arms in public for that purpose. Evidence from around the adoption of the 14th Amendment also does not support respondents' position. The discussion of the right to keep and bear arms in Congress and in public discourse, as people debated whether and how to secure constitutional rights for newly free slaves, generally demonstrates that during Reconstruction, the right to keep and bear arms had limits that were consistent with the right of the public to peaceably carry handguns for self-defense. The court acknowledges 2 Texas cases, English v. State and State v. Duke, that approved a statutory reasonable grounds standard for public carry analogous to New York's proper cause requirement. But these decisions were outliers and therefore provide little insight into how post-bellum courts viewed the right to carry protected arms in public. Finally, respondents point to the slight uptick in gun regulation during the late 19th century. As the court suggested in Heller, however, late 19th century evidence cannot provide much insight into the meaning of the Second Amendment when it contradicts earlier evidence. In addition, the vast majority of the statutes that respondents invoke come from the Western territories. The bare existence of these localized restrictions cannot overcome the overwhelming evidence of an otherwise enduring American tradition permitting public carry. Moreover, these territorial laws were rarely subject to judicial scrutiny, and absent any evidence explaining why these unprecedented prohibitions on all public carry were understood to comport with the Second Amendment, they do little to inform the origins and continuing significance of the amendment. Finally, these territorial restrictions deserve little weight because they were, consistent with the transitory nature of territorial government, short-lived. Some were held unconstitutional shortly after passage, and others did not survive a territory's admission to the Union as a state. After reviewing the Anglo-American history of public carry, the court concludes that respondents have not met their burden to identify an American tradition justifying New York's proper cause requirement. Apart from a few late 19th century outlier jurisdictions, American governments simply have not broadly prohibited the public carry of commonly used firearms for personal defense, nor have they generally required law-abiding responsible citizens to demonstrate a special need for self-protection, distinguishable from that of the general community, to carry arms in public. The constitutional right to bear arms in public for self-defense is not a second-class right subject to an entirely different body of rules than the other Bill of Rights guarantees. The exercise of other constitutional rights does not require individuals to demonstrate to government officers some special need. The Second Amendment right to carry arms in public for self-defense is no different. New York's proper cause requirement violates the 14th Amendment by preventing law-abiding citizens with ordinary self-defense needs from exercising their right to keep and bear arms in public. The judges in Bruen were Thomas, who delivered the opinion of the court, in which Roberts, Alito, Gorsuch, Kavanaugh, and Barrett joined. Alito filed a concurring opinion. Kavanaugh filed a concurring opinion in which Roberts joined. Barrett filed a concurring opinion. Breyer filed a dissenting opinion in which Sotomayor and Kagan joined. So this was a 6-3 decision. Now the opinion of the court in Bruen, delivered by Justice Clarence Thomas. In District of Columbia v. Heller and McDonald v. Chicago, we recognize that the Second and 14th Amendments protect the right of an ordinary law-abiding citizen to possess a handgun in the home for self-defense. In this case, petitioners and respondents agree that ordinary law-abiding citizens have a similar right to carry handguns publicly for their self-defense. We too agree and now hold, consistent with Heller and McDonald, that the Second and 14th Amendments protect an individual's right to carry a handgun for self-defense outside the home. The parties nevertheless dispute whether New York's licensing regime respects the constitutional right to carry handguns publicly for self-defense. In 43 states, the government issues licenses to carry based on objective criteria. But in 6 states, including New York, the government further conditions issuance of a license to carry on a citizen's showing of some additional special need. Because the state of New York issues public carry licenses only when an applicant demonstrates a special need for self-defense, we conclude that the state's licensing regime violates the Constitution. New York State has regulated the public carry of handguns at least since the early 20th century. In 1905, New York made it a misdemeanor for anyone over the age of 16 to have or carry concealed upon his person in any city or village of New York any pistol, revolver, or other firearm without a written license issued to him by a police magistrate. In 1911, New York's Sullivan Law expanded the state's criminal prohibition to the possession of all handguns, concealed or otherwise, without a government-issued license. New York later amended the Sullivan Law to clarify the licensing standard. Magistrates could issue to a person a license to have and carry a concealed pistol or revolver without regard to employment or place of possessing such weapon, only if that person proved good moral character and proper cause. Today's licensing scheme largely tracks that of the early 1900s. It is a crime in New York to possess any firearm without a license, whether inside or outside the home, punishable by up to 4 years in prison or a $5,000 fine for a felony offense, and 1 year in prison or a $1,000 fine for a misdemeanor. Meanwhile, possessing a loaded firearm outside one's home or place of business without a license is a felony punishable by up to 15 years in prison. A licensed applicant who wants to possess a firearm at home or in his place of business must convince a licensing officer, usually a judge or law enforcement officer, that, among other things, he is of good moral character, has no history of crime or mental illness, and that no good cause exists for the denial of the license. If he wants to carry a firearm outside his home or place of business for self-defense, the applicant must obtain an unrestricted license to have and carry a concealed pistol or revolver. To secure that license, the applicant must prove that proper cause exists to issue it. If an applicant cannot make that showing, he can receive only a restricted license for public carry, which allows him to carry a firearm for a limited purpose, such as hunting, target shooting, or employment. No New York statute defines proper cause, but New York courts have held that an applicant shows proper cause only if he can demonstrate a special need for self-protection distinguishable from that of the general community. This special needs standard is demanding. For example, living or working in an area noted for criminal activity does not suffice. Rather, New York courts generally require evidence of particular threats, attacks, or other extraordinary danger to personal safety. When a licensing officer denies an application, judicial review is limited. New York courts defer to an officer's application of the proper cause standard unless it is arbitrary and capricious. In other words, the decision must be upheld if the record shows a rational basis for it. The rule leaves applicants little recourse if their local licensing officer denies a permit. New York is not alone in requiring a permit to carry a handgun in public, but the vast majority of states, 43 by our count, are shall-issue jurisdictions, where authorities must issue concealed carry licenses whenever applicants satisfy certain threshold requirements without granting licensing officials discretion to deny licenses based on a perceived lack of need or suitability. Meanwhile, only 6 states and the District of Columbia have may issue licensing laws, under which authorities have discretion to deny concealed carry licenses even when the applicant satisfies the statutory criteria, usually because the applicant has not demonstrated cause or suitability for the relevant license. Aside from New York, then, only California, the District of Columbia, Hawaii, Maryland, Massachusetts, and New Jersey have analogs to the proper cause standard. All of these proper cause analogs have been upheld by the Court of Appeals, save for the District of Columbia's, which has been permanently enjoined since 2017. As set forth in the pleadings below, petitioners Brandon Koch and Robert Nash are law-abiding adult citizens of Rensselaer County, New York. Koch lives in Troy, while Nash lives in Averill Park. Petitioner, New York State Rifle and Pistol Association, is a public interest group organized to defend the Second Amendment rights of New Yorkers. Both Koch and Nash are members. In 2014, Nash applied for an unrestricted license to carry a handgun in public. Nash did not claim any unique danger to his personal safety. He simply wanted to carry a handgun for self-defense. In early 2015, the state denied Nash's application for an unrestricted license, but granted him a restricted license for hunting and target shooting only. In late 2016, Nash asked a licensing officer to remove the restrictions, citing a string of recent robberies in his neighborhood. After an informal hearing, the licensing officer denied the request. The officer reiterated that Nash's existing license permitted him to carry concealed for purposes of off-road, backcountry, outdoor activities similar to hunting, such as fishing, hiking, and camping. But at the same time, the officer emphasized that the restrictions were intended to prohibit Nash from carrying concealed in any location typically open to and frequented by the general public. Between 2008 and 2017, Koch was in the same position as Nash. He faced no special dangers, wanted a handgun for general self-defense, and had only a restricted license permitting him to carry a handgun outside the home for hunting and target shooting. In late 2017, Koch applied to a licensing officer to remove the restrictions on his license, citing his extensive experience in safely handling firearms. Like Nash's application, Koch's was denied, except that the officer permitted Koch to carry to and from work. Respondents are the superintendent of the New York State Police, who oversees the enforcement of the state's licensing laws, and a New York Supreme Court justice who oversees the processing of licensing applications in Rensselaer County. Petitioners sued respondents for declaratory and injunctive relief, alleging that respondents violated their Second and 14th Amendment rights by denying their unrestricted license applications on the basis that they had failed to show proper cause. That is, had failed to demonstrate a unique need for self-defense. The district court dismissed petitioner's complaint, and the Court of Appeals affirmed. Both courts relied on the Court of Appeals' prior decision in Kalchowski, which had sustained New York's proper cause standard, holding that the requirement was substantially related to the achievement of an important government interest. We granted certiorari to decide whether New York's denial of petitioner's license applications violated the Constitution. All right, folks, that wraps up part 1 of 7 of my reading of Bruen, which was the first quarter of Justice Thomas's majority opinion. Next time we meet, I'll share with you the second of 7 parts, the second quarter of Justice Thomas's majority opinion. See you there. If you like this kind of content, and I know you do, that's why you're here, you may as well consider becoming a Law of Self-Defense member. It's dirt cheap to at least try it out. You can get a 2-week trial membership for only 99 cents. Just go to lawofselfdefense.com/trial to sign up for that. In the unlikely event you don't like it and you'd like your money back, we'll give you a 200% refund. Most people, almost everyone, stays a member, and just being a standard member of Law of Self-Defense is dirt cheap. It's only about 30 cents a day, less than $10 a month. To be a member of Law of Self-Defense, get unlimited access to all our members-only content. It's the only way to have your comments and questions on live streams be addressed by me. You get a members-only podcast. Much of our content is limited, so only members can access it. Get all that and much more at lawofselfdefense.com/trial. Just try it out for 2 weeks, 99 cents, 200% money back guarantee. It's a negative risk opportunity. I hope you see you as a member real soon.